Okay, we are now on the Title 2 of the Revised Corporation Code of the Philippines. So under the Title 2 is the Incorporation and Organization of Private Corporations. So Section 10, Number and Qualifications of Incorporators. Ito yung mga names na mag-a-appear dun sa Articles of Incorporation. So any person, partnership, association, or corporation, singly or jointly with others, but not more than 15 in number. So maximum pareho lang. Dito sa old law, if you would note, ayan not less than 5. Wala na yung not less than 5 kasi meron na tayong tinatawag na one-person corporation. So, a single individual can file or can be an incorporator. So, wala nang minimum of 5 niya because of the one-person corporation. Pero nandun pa rin tayo sa limitation or ceiling or maximum of 15 incorporators. Kasi kung masyado marami, ilalagay mo yan sa Articles of Incorporation, baka hindi na matapos yung Articles of Incorporation. So, incorporators lang naman ito. Yung mga names ng stockholders or corporators na mag-a-appear sa Articles of Incorporation. Okay? Provided, may proviso, that natural persons who are licensed to practice a profession and partnerships or associations organized for the purpose of practicing a profession shall not be allowed to organize as a corporation unless otherwise provided under special laws. Incorporators who are natural persons must be of legal age. Okay? So yung partnership, general professional partnership, hindi sila pwedeng mag-incorporate unless there is a special law granting them the right to incorporate. Each incorporator of a stock corporation must own or be a subscriber of at least 1 share of capital stock. A corporation with a single stockholder is considered as one-person corporation. Okay? So dito sa corporate term or life ng corporation, under the old law, 50 years ang maximum life ng isang corporation. Magpa-file ka na naman ng bagong Articles of Incorporation after 50 years kung gusto mong ituloy ang corporation. But under the Revised Corporation Code, perpetual na yung existence ng corporation. Unless indicated in the Articles of Incorporation, a limitation on that perpetual existence. Kunyari, nilagay sa Article of Incorporation na for 50 years na siya or 25 years. So that's the time na hindi na perpetual yung existence niya. Pero without those reservation or those conditions, life ng corporation is now perpetual, hindi na maximum of 50 years. Corporations with certificate of incorporation issued prior to the effectivity of this code and which continue to exist shall have perpetual existence unless a corporation, upon a vote of its stockholders representing a majority of its outstanding capital stock, notifies the Commission that it elects to retain its specific corporate term pursuant to its Articles of Incorporation, provided that any change in the corporate term under this section is without prejudice to the appraisal right of dissenting stockholders in accordance with the provisions of this code. So yung mga existing na corporation, presumed na perpetual na sila. Ang rule is that kung hindi sila magpa-file ng new articles of unless i-elect nila at ino-notify nila yung commission that they elected to have the original term indicated in the Articles of Incorporation. Perpetual yung life nila. Let me rephrase it again, medyo magulo. Yung mga existing na corporation, considered na as perpetual yung kanilang existence. Unless mag-notify sila sa commission na nag-elect sila, there must be an election to the effect na yung original term nila under the Articles of Incorporation previously filed with the SEC ay yun ang susundin nila. Okay? Pero meron pa rin right of dissenting stockholders appraisal. So, kung may nagdi-dissent na stockholders, pag-aaralan pa rin. At i-consider pa rin yung application ng perpetual term of corporate existence. The corporate term provided for a specific period may be extended or shortened. Provided that no extension shall be made earlier than 3 years prior to the original or subsequent expiry dates. So, 3 years before the expiration of the term of the corporation, kailangan mag-file ng amendment to the Articles of Incorporation. But not earlier than 3 years. So, kunyari, 4 years pa, magpa-file ka na, hindi pwede. Kailangan 3 years before the expiration. Okay? Okay, a corporation whose term has expired may apply for revival of its corporate existence together with all the rights and privileges under its certificate of incorporation and subject to all of its duties, debts, and liabilities existing prior to its revival. Upon approval by the Commission, the corporation shall be deemed revived, and a certificate of revival of corporate existence shall be issued, giving it perpetual existence, unless its application for revival provides otherwise. So nag-expire na yung life ng corporation, pwede mag-file ng revival. So no application for revival of certificate of incorporation of banks, banking and quasi-banking institutions, pre-need insurance and trust companies, non-stock savings and loan associations or LAs, pawn shops, corporation engaged in money service, business, and other financial intermediaries shall be approved by the Commission unless accompanied by a favorable recommendation of the appropriate government agency. So, appropriate government agency dito is Bangko Sentral. So, medyo mahigpit na yung corporate term pagdating sa mga banks, no? Maraming requirement. Okay, minimum capital stock required. Stock corporation shall not be required to have a minimum capital stock except as otherwise specifically provided by special laws. So, palagi ninyong nakikita yung special law, diba? When it comes to corporation code, this is the general law because this is the law that governs all transactions involving corporation. Now, if later on the Congress will approve some laws which affect the provisions of the corporation, of the existence of the corporation, then that will be considered as a special law. So, Ito na yung general law on the corporation because this is the codification of all the laws regarding corporation. If later on may mga special law, may mga batas na ginagawa ang Congress that affect the corporation law or the revised corporation law, then that will be considered as special law. Okay? Baka hindi nyo maintindihan, ano ba yung special law? Baka akala nyo meron ng special law. So the Congress kasi may every now and then pass a law. So, kunyari, merong batas na pinasa yung Congress na nagsasabi na itong corporation na to para sa mga disabled will be ganon-ganon. So, special law yun. That is a special law because that is a corporation for disabled people. Now, kung magko-contradict itong revised corporation code at saka yung special law on the nakinrate ng Congress, then ang magpre-prevail yung special law na yon, hindi itong corporation code na to, revised corporation code na to. Okay, under section 13, meron ditong provision under the old law, the requirement of capital stock to be subscribed and paid for, nakalagay 25% of the authorized capital stock and 25% thereof must be subscribed. So anong sabi? 25% of the authorized capital stock must be subscribed. And 25% of that subscribed must be paid. Pero under the present code, wala na yang requirement na yan. So kung may mga problem pa na sa examination na nagre-require, compute kayo ng how much must be paid up, how much must be subscribed, ano na yon, moot and academic na yon. It cannot be asked anymore because there is no law ngayon na nagre-require ng subscription ng 25% and paid up capital na 25%. So, Section 13 tayo, contents of articles of incorporation, pareho lang under the old law. So, nothing to discuss about. Basahin nyo na lang kung ano-ano itong mga dapat ilagay sa articles of incorporation para pag magda-draft ng corporation, articles of incorporation, alam niyo na, this is just a sample. Ito na pagkakaiba. Etong the number of directors or trustees which shall not be more than 15. Ito nakalagay which shall not be less than 5 nor more than 15. Ito 1 to 15. Pwedeng isa lang. Kasi nga, ay one person corporation. Yun lang yung pagkakaiba. The names and nationalities, if the stock, pareho lang. So, ito meron lang, itong Securities and Exchange Commission shall not, wala na yan. Ito, burado na yan. Hindi na yan kasali. So, ito naman, may in-insert ang bagong batas. An arbitration agreement may be provided in the Articles of Incorporation pursuant to Section 181 of this code. So, may incorporate na yung arbitration agreement dun sa Articles of Incorporation. The Articles of Incorporation applications for amendments thereto may be filed with the Commission in the form of an electronic document in accordance with the Commission's rules and regulations on electronic filing. O dati lahat manual, ngayon pwede na yung e-filing sa Securities and Exchange Commission. Pwede kayo mag-search sa sa YouTube kung paano yung electronic filing. Okay? Forms of articles of incorporation, pareho lang ng old law. So, pero this time, meron tayong tinatawag na one-person corporation. Okay? Hindi na, ito nakalagay, or OPC. So, ibig sabihin, one-person corporation. Pareho lang. Okay? Ito sa dati, walang addresses, no? na word, residence addresses of the incorporators. Pareho lang, nilagay lang yung word ng addresses. So, yan yung format ng Articles of Incorporation. So, dito dun sa portion na number 8, wala na yung that at least 25% of the authorized capital shares of stock has been subscribed. Okay, hindi na kailangan yon. So, dito indicate na lang yung kung sino-sino yung subscriber, nationality, number of shares subscribed, amount subscribed, and amount paid. Hindi mo na itototal yan para mag-represent ng 25%. Modify number 8 if shares of stock are with no par value. In case the corporation is non-stock, number 7 and 8 of the above articles may be modified accordingly, and it is sufficient if the articles state the amount of capital or money contributed or donated by specified persons, specifying the names, nationalities, and residence addresses of the contributors or donors and the respective amount given by each. Okay? Kung non-stock kasi ito, wala na itong number of shares, subscribed, amount paid. Kundi name of, hindi rin name of subscriber kasi non-stock yan. So magiging name of donor, nationality of donor, kung ano yung dinonate, amount nung dinonate, gano'n na lang. I-modify na lang yan to conform with the non-stock nature of the corporation. Kasi non-stock nga, wala kang pag-uusapan na stock. Ang pag-uusapan nyo dun yung contribution in terms of money or other property or donation in terms of money or other property. Yun ang i-account dito sa ating listahan na ito. So, kailangan merong naka-indicate 9. Ito, pareho lang ito ng itong 9th provision, katulad lang din ito ng 10th provision. Mahirap basahin itong sa ano. Teka, basahin natin kahit mahirap. That has been elected, yung treasurer, that the name of the treasurer has been elected. Ito yung certification as the election of the treasurer. Okay? Okay. Ito dito na lang natin basahin. Ito yun. Now, on that, meron lang dinagdag ito doon sa 10. The incorporators undertake to change the name of the corporation immediately upon receipt of notice from the commission that another corporation, partnership, or person has acquired a prior right to the use of such name, that the name has been declared not distinguishable from a name already registered or reserved for the use of another corporation, or that it is contrary to law, public morals, good customs, or public policy. So, pag mag-apply ka kasi sa SEC ng corporate name, meron tinatawag na reservation. Ipa-file mo muna yung application for reservation of a corporate name. Tapos, i-verify muna yan ng, di nakagawa ka na ng articles of incorporation at meron ka ng na-prepare na articles of incorporation, yun yung sinubmit mo sa SEC. Pero upon review or scrutiny ng SEC, meron na palang ibang corporation na nagmamay-ari ng pangalan na yon, then you have to change the name of your corporation. So, minsan matagal mag-file, mag-process because yung names nyo ng corporation, meron ng kamukhang pangalan. Okay, so the 11 corporation will engage in business activity reserve. So, tingnan natin kung may pagbabago. Yung nationalized corporation, ito yung tinatawag na nationalized corporation. Corporation which will engage in any business or activity reserved for Filipino citizens shall provide for the following. So, no transfer of stock interest which shall reduce the ownership of the Filipino citizens to less than the required percentage of the capital stock as provided by existing law shall be allowed or permitted to be recorded in the proper books of the corporation. And this restriction shall be indicated in all stock certificates. Kaya maraming dami kasi meron tayong mga nationalized business. Tapos hindi makakapag-participate doon yung mga foreigner. Pero nakakapag-participate pa rin sila using other Filipinos who would work as dummy for them. Ito yan. Pero wala tayong magawa kasi minsan kulang din yung local investors. So yung iba nagre-resort sa ganong mechanism. So ito yung acknowledgement ng articles of incorporation. It should be notarized. Wala na nga lang treasurer's affidavit. At sa lumang batas, kailangan ng treasurer's affidavit because may requirement na 25% subscription and payment of the share of capital stock. Kailangan 25% ng authorized capital stock is subscribed and 25% of the subscribed is paid up. Wala nang ganyan affidavit under the new law because hindi na required yung 25% na yan. Okay? Amendments to the articles of incorporation. Unless otherwise prescribed by this code or by special law or for legitimate purposes, any provision or matter stated in the articles of incorporation may be amended by a majority vote of the board of directors or trustees and the vote or written assent of the stockholders representing 2/3 of the outstanding capital stock without prejudice to the appraisal right of the dissenting stockholders in accordance with the provision of this code. So ano requirement for the amendment of the articles of incorporation? Majority vote of the board of directors. Majority vote of the members of the board of directors. So anong sabi yung ating corporation? Corporation, di ba? 15 ang ating incorporators. Ilan ang directors, members ng board doon? So yung majority ng members ng board of directors, yun yung kailangan natin plus the vote or written assent of the stockholders representing at least 2/3 of the outstanding capital stock. So, kwantahin mo yung 2/3 ng outstanding capital stock. Tapos, sino-sino yung holder ng shares na yon? 2/3 of those issued shares or outstanding shares holders should vote for the amendment. Ang tawag natin kapag stock corporation, directors, board of directors. Pero pagka non-stock corporation yan, board of trustees. So, trustees ang tawag sa non-stock corporation. Baka nakakakita kayo ng dito, ng trustees, di nyo maintindihan. Magkakaiba ng pangalan. Kung stock corporation yan, tawag dyan ay Board of Directors. Kung non-stock, ang tawag ay Board of Trustees. Okay. Pareho lang din sa lumang batas. Yung requirement, the original amendment, may konting pababago. The original and amended articles together shall contain all provisions by law to be set up in the articles of incorporations. Amendments to articles shall be indicated by underscoring the change or changes made and a copy thereof duly certified under oath by the corporate secretary and majority of the directors or trustees with a statement that the amendments have been duly approved and required by the required vote of the stockholders or members. Okay? The amendment shall take effect upon their approval by the commission or from the date of filing with the commission, if not acted upon within 6 months from date of filing for a cost not attributable to the corporation. Parang batas lang, no? Pag ang batas ginawa ng Congress, binigay sa Office of the President, hindi pinirmahan ng Office of the President within a specified period, then that law becomes a law even without the signature of the President. Ganon din ito. Kapag yung amendment to the Articles of Incorporation, fully complied naman lahat ng requirements at hindi na aksyonan ng SEC within 6 months, then all the amendments shall take effect after that 6-month period. Grounds when articles of incorporation or amendment may be disapproved. So, ito yung mga grounds for disapproval. The articles of incorporation or any amendment thereto is not substantially in accordance with the form prescribed herein. So yung form na pinakita natin kanina, kailangan yun ang masunod. Kung hindi, madi-disallow yung application. The purpose or purposes of the corporation are patently unconstitutional, illegal, immoral, or contrary to government rules and regulations. The certification concerning the amount of capital stock subscribed, kailangan pa ba to? Siguro hindi lang nila na-omit. Kasi dito, so kailangan pa rin ng dito, kailangan pa rin ng subscription. Kailangan pa rin ng authorized capital stock at subscription, pero hindi na nga lang 25%. Therefore, maglalagay ka pa rin ng subscription at saka paid in list. Hindi na nga lang kailangan 25%. The required percentage of Filipino ownership has not been complied with. Ito yung sinasabing nationalized corporation na kailangan 60% ng ownership ay Filipino, ay of Filipino citizens. So kapag hindi yun na-comply, hindi yun magkakaroon ng madi-deny yung application. No articles of incorporation of banks, banking, quasi-banking institutions, pre-need insurance, non-stock savings and loan associations, pawn shops, and other financial intermediaries shall be approved by the commissioner unless accompanied by a favorable recommendation of the appropriate government agency. Okay. Bangko Sentral yung appropriate agency dyan. Kailangan merong approval ng Bangko Sentral and other government agency na required sila mag-comply. So corporate name, if it is not distinguishable from that already reserved or registered for the use of other corporation, or if such name is already protected by law when its use is contrary to existing laws and regulation. So ito yung mga hindi pwedeng i-register na corporate name. May kamukha ng naka-reserve, ginagamit na ng iba. Kung yung name na yan ay protected by law or contrary to existing law and rules and regulation. When is a name not distinguishable, even if contains one or more of the following? The word corporation, company, or other. Ito, kapag yung isang name may corporation tapos ikaw meron, wala, hindi pa rin yan distinguishable kung ang difference lang itong mga words na ito. So, kahit na yung isa wala, ikaw meron, siya wala, hindi pa rin yan distinguishable. Okay, ito punctuations, articles, and conjunction spacing. So, it does not create distinction. Ang ibig sabihin lang nito. The commission upon determination that the corporate name is not distinguishable. Anong gagawin ng commissioner kapag hindi distinguishable yung name? Ito, the commission shall cause the removal of all visible signages, marks, advertisement, on other effects bearing such corporate name. Upon the approval of the new corporate name, the commission shall issue a certificate of incorporation under the amended name. So kahit na nag-file ka under your articles of incorporation, ganyan yung pangalan mo, hindi naman yan yung pwede mong pa-approve na pangalan. Nag-preserve ka ng panibagong pangalan, naka-file na yung sa SEC yung application mo bearing an old name. Pag-issue ng SEC ng bagong pangalan, i-amend mo na yung articles of incorporation mo to reflect the approved name. If the corporation fails to comply with the commission's order, the commission may hold the corporation and its responsible directors or officers in contempt and hold them administratively, civilly, and criminally liable under this code. O yun, nag-apply ka under this name, may kamukhang name, nag-preserve ka ng ibang name, at yun ang na-approve na name ng SEC. Pero ang ginamit mo pa ring name yung nandun sa original articles of incorporation mo, despite the fact na na-deny yun ng SEC, magkakaroon ka ng criminal liability. Okay, registration, incorporation, and commencement of corporate existence. A person or a group of persons desiring to incorporate shall submit the intended corporate name to the commission for its verification. If the commission finds that the name is distinguishable from other already reserved or registered for the use of another corporation not protected by law or not contrary to law, rules and regulation shall be reserved in favor of the incorporators. The incorporators shall then submit their articles of incorporation bylaws to the commission. If the commission finds that the submitted documents and information are fully compliant with the requirements of this code, other than relevant laws, rules, and regulations, the commission shall issue the certificate of incorporation. A private corporation organized under this code commences its corporate existence and judicial personality from the date the commission issues the certificate of incorporation under its official seal, and thereupon the incorporator, stockholders, members, and their successors shall constitute the body corporate under the name stated in the Articles of Incorporation for the period of time mentioned therein, unless said period is extended or the corporation is sooner dissolved in accordance with law. So, tingnan natin, hindi pala, gagawa lang muna ng reservation pala. Pero minsan kasi may mga de facto corporation, no? Hindi pa nila nare-register sa SEC. Nag-a-act na sila under that name. So, if later on, yung pinareserve nilang name hindi na-approve at meron silang transaction under that proposed name, anong mangyayari? Meron silang mga civil liability. So, it's best na makuha na lang muna talaga yung original approved name from the SEC bago sila mag-transact with other people. So de facto corporations, the due incorporation of any corporation claiming in good faith to be a corporation under this article and its right to exercise corporate power shall not be inquired into collaterally in any private suit to which such corporation may be a party. Such inquiry may be made by the Solicitor General in a quo warranto proceeding. Anong ibig sabihin nun? Kung private lang naman, private party lang naman. So between parties, these are de facto corporation, and de facto corporation has the right to exercise corporate powers as between parties. Kung naniwala ka sa kanya na de facto corporation siya, even if hindi siya hindi complete yung registration niya, kunyari on process pa lang, yun yung sinasabing nandun pa lang siya sa reservation ng corporate name, na-accomplish na yung ibang task, nandun na siya sa reservation ng corporate name, inaantay pa niya yung approval. Hindi siya fake na corporation, on process yung kanyang application, so it is considered as de facto corporation. So in a private suit, kunyari A corporation, de facto corporation, nagtansak kay B na naniwala na existing corporation siya, hindi niya pwedeng gamitin yon as hindi niya pwedeng questionin yung failure to comply ni A sa regulation, kasi nung nag-represent sa kanya si A, de facto corporation na siya, na nagko-comply siya talaga. Hindi siya fake na corporation, on process pa. So, corporation by estoppel. Ito naman, iba. Hindi naman siya nagko-comply as corporation talaga. Pero gumagawa siya ng acts of a corporation knowing na wala itong authority. Ano ang liability niya? As a general partner for all the debts and liabilities and damage incurred or arising as a result thereof. No? Well, provided, however, that when any such ostentable corporation is sued or any transaction entered by it as a corporation or on any tort committed by it as such, it shall not be allowed to use it as lack of corporate personality as a defense. So, ito naman, nagkaroon ng liability yung corporation. Sasabihin, hindi yung corporation kaya wala na siyang liability. Hindi pwede. Mako-consider pa rin sila as corporation for purposes of payment of liabilities. Anyone who assumes an obligation to an ostensible corporation as such cannot resist performance thereof on the ground that there was in fact no corporation. Yun yung in-explain ko. Okay, effects of non-use or of corporate charter and continuous an operation. Kapag hindi nag-operate yung corporation, na-register lang pero hindi naman nagawa ng business. So within 5 years from the date of its incorporation, its certificate of incorporation shall be revoked as of the day following the end of the 5-year period. Kapag ikay nag-file, tapos di ka nagpa-file ng ng income tax return mo sa BIR along with financial statements after the approval of the corporate name or after the registration approval, automatic marirevoke yung 5-year marirevoke yung registration mo. Ito sa lumang batas, 2 years lang. 2 years lang. However, if a corporation has commenced the transaction of its business but subsequently becomes continuously inoperative for a period of at least 5 years, shall have the ground for the suspension of the revocation of corporate existence or franchise. Shall have the ground. Ibig sabihin, ipaprocess pa. Pero ito kasi, it is deemed revoked. However, if a corporation has commenced its business but subsequently becomes inoperative for a period of at least 5 consecutive years, the Commission may, after due notice and hearing, place a corporation under delinquent status. Ano yung pagkakaiba ng dalawang batas? Sa unang batas, kapag di ka nag-commence within 2 years, magkakaroon ng ground yung SEC na i-dissolve yung corporation. Within 2 years, at di nag-operate, deemed dissolved na yon. Deemed dissolved. Ngayon, dito sa bagong batas, after 5 years, within 5 years rather, hindi nag-operate after approval of certificate of registration, the certificate of incorporation shall be deemed revoked following the end of the 5-year period. However, ito namang sa kabila, dun sa old law, kung nag-operate siya within 2 years, pero naging inoperative siya for at least 5 years, the ground for the suspension of revocation, there will be a ground for revocation of its corporate franchise or certificate. Papadala na ng commission ng notice and hearing. Doon sa una, yung automatic revocation. Kung nag-register ka tapos di ka nag-operate within 5 years, automatic revocation yon. Pero kunyari, nag-operate ka tapos for 5 years, huminto ka ng operation, yun, magkakaroon ka pa ng hearing. Hindi automatic yung revocation. Bibigyan ka pa ng due process. Pero sa una, wala nang due process yung basta pagka ikay nagpa-register at di ka nag-operate within 5 years, automatic revocation na. A delinquent corporation shall have a period of 2 years to resume operations and comply with all the requirements that the Commission shall prescribe. Upon the compliance of the corporation, the Commission shall issue an order lifting the delinquent status. Failure to comply with the requirements and resume operations within the period given by the Commission shall cause the revocation of the corporation's certificate of incorporation. Okay. Nagpa-register ka, na-approve. Nag-operate ka, huminto ka. Kailangan huminto ka ng 5 years. 5 years ka huminto, ilalagay ka na sa delinquent status. Magkakaroon na ng hearing yan. Kailangan, after the notice, magkaroon ka na ng operation or mag-comply ka sa requirements ng commission bago ka makapagsimula uli ng iyong operation as business. Hindi pwedeng 5 years ka huminto, tapos nailagay ka na sa delinquent status, mag-ooperate ka basta-basta. Hindi pwede yon. Pero huminto ka for 4 years, tapos nag-operate ka uli, hindi mo kailangan ng mag-comply kasi within 5 years naman yun eh. Pero pag lumampas ka na ng 5 years at nalagay ka na sa delinquent status, kailangan mo mag-comply. Kung di ka magko-comply, marerevoke na yung iyong registration. Okay? Atong Title 3, Qualifications, basahin niya na lang yan. Pero may bagong the board of the following corporations vested with public interest shall have independent directors constituting at least 20% of such board. So bago tong provision na ito, sino yung tinatawag na independent directors? Paano ka mako-consider na member or director, independent director? So these are matters to be learned as the law is being implemented. So maraming legal cases about this that will be resolved to determine this independent directors. Bago kasi ito ano tong independent directors na to. History will tell us kung ano nga yan, directors na yan. Corporations covered by section. Okay, stop muna tayo dito.